9 months. That's the gap between inland and outland spousal sponsorship right now. IRCC's current processing times 15 months outland, 24 months inland. Most couples only find out after they've already filed. Hi, I'm Bella. I'm a regulated Canadian immigration consultant and the founder of Langille Immigration here in Nova Scotia. I work with couples going through exactly this decision. And in this video, I want to give you the full picture, both sides, the real trade-offs. Because inland isn't always wrong and outland isn't always right, but you need to know what you're actually choosing between. Here's why this matters right now in 2026 specifically. The gap between these two streams has never been wider. Stricter scrutiny, higher refusal rates, and a processing environment with the wrong stream choice can mean the difference between your spouse working legally in Canada next year or waiting to. This is not a checklist video. This is the conversation I have with clients before they file. Let's get into it. Most people think inland just means my spouse is in Canada and outland means my spouse is overseas. That's not quite right, and the difference matters legally. These are two completely separate legal classes under the Immigration and Refugee Protection Regulations. The technical name for inland is the spouse or common law partner in Canada class. Outland falls under the broader family class. Why does that matter? Because the eligibility requirements are fundamentally different. To qualify for inland, your spouse must meet 3 conditions, all 3 at the same time. 1, they must be your spouse or common law partner. 2, they must be physically cohabitating with you in Canada. 3, they must hold valid temporary resident status, a valid visitor record, study permit, or work permit. That third one catches people. If your spouse status has lapsed even by a few days, they fall outside the legal definition of the inland class. Here's the part most videos skip entirely, and it changes the math completely. Outland, no requirement to be physically in Canada, no temporary resident status required during processing, and if your spouse is in Canada on valid status, they can still choose to apply outland. That flexibility is the first thing worth knowing. Back to those numbers. 15 months outland, 24 months inland. IRCC's processing time tool updates regularly. Always check Canada.ca directly before making any decision. But that gap has been consistent. Why? A few reasons. Inland application carried extra layer of scrutiny on status maintenance. IRCC is checking not just whether the relationship is genuine, they're tracking whether your spouse has stayed in valid status throughout the entire processing period. That adds complexity, that adds time. Outland files, particularly overseas, move through visa offices that often have lower volume than inland processing centers. That review process doesn't carry the same status monitoring burden. 9 months is real. That could be a full year of your lives. Financial planning, employment, mental health is not a footnote. One of the biggest reasons people choose inland is the spousal open work permit. The idea is to apply inland, get a work permit within a few months, your spouse starts working. Problem solved. Here's what's changed. As of right now, if your spouse is physically in Canada, lives with you, and holds valid temporary resident status, they can apply for the spousal open work permit under either stream, not just inland. Read that again. Outland applications in Canada can now access the same work permit. So that advantage is no longer exclusive to inland. And the key requirements are your spouse needs to be with you in Canada, have valid status, and have received their acknowledgement of receipt, the AOR letter, confirming the PR application is in processing. One procedural note, when filling out the work permit application form, the job title field should say SCLPC, FCOWP, and the duties description should say SCLPC, FC applicant in Canada public policy. Exactly that. Not a code you found on Reddit. This comes directly from IRCC's official guide last updated April 2026. The spousal open work permit public policy currently runs until December 31st, 2026. Always check Canada.ca for any updates before you apply. If you're at this decision point right now, inland or outland, and you're not sure which one fits your situation, that's exactly what a strategy session is for. You can find the link in the description below. This is the one most couples don't find out about until it's too late. If your inland application is refused, IRCC decides the relationship isn't genuine or there is a procedural issue, you have no right of appeal to the Immigration Appeal Division. None. The official IRCC guide says it plainly. You can't appeal our decision if you are sponsoring them under the spouse or common law partner in Canada class. Your options if that happens: 2. File a completely new application and start over, or apply to the federal court for judicial review. And judicial review is expensive, slow, and narrow. The court isn't rereading your love letters. It's asking only one question. Did the officer make a legally unreasonable decision based on the evidence in front of them at the time? Outland is different. Under Section 63(1) of the Immigration and Refugee Protection Act, a refused family class spousal sponsorship carries a full right of appeal to the Immigration Appeal Division. That's a real hearing, fresh evidence, live testimony, a genuine second look at your relationship. And there is a specific protection Parliament carved into the legislation. Even if there is a misrepresentation finding, the right of appeal is preserved for spouses and common law partners. So here is the honest question you have to ask before you file. What's your risk tolerance if this goes wrong? If there's any complexity in the file, prior refusals, complicated immigration history, a relationship that developed entirely online, a significant age gap, the appeal safety net that only Outland provides becomes the more important variable. That's not a prediction about your case. It's a framework for thinking about the decision. This one catches couples off guard constantly. If your spouse applies inland and then travels outside of Canada during processing, there's no guarantee CBSA will let them back in. The IRCC instruction guide is explicit. If an applicant living in Canada leaves the country while their application is being processed, there is no guarantee that they will be allowed to re-enter Canada. This is particularly true for individuals who require a visitor visa to enter. A CBSA officer at the port of entry has full authority to deny re-entry, even with a valid TRV, even with a pending PR application, because their job is to assess whether your spouse genuinely intends to leave if the PR doesn't come through. And a pending PR application can actually work against them in that moment. If entry is denied, the inland application isn't just paused, it's done. The legal requirement for the inland class is cohabitation in Canada. The moment your spouse is physically barred from Canada, they break that requirement. The application is abandoned, fees gone, time gone, start over under Outland. That's not a theoretical risk. It happens. So if your spouse anticipates any travel during processing, family emergency, work obligation, visa situation, inland is not the right choice, period. Outland carries none of that risk, which brings me to dual intent. A lot of couples choose Outland thinking it means months of separation. It doesn't have to be. Dual intent is explicitly recognized in Canadian law. Section 22(2) of the Immigration, Refugee and Protection Act says directly, having the intention to become a permanent resident does not prevent a foreign national from entering as a temporary resident. Your spouse can apply for a visitor visa while the PR application is processing. Officers reviewing that TRV application are specifically instructed to consider whether there is a pending sponsorship. And if your spouse already has the AOR in hand, they may qualify for faster TRV processing. What IRCC is looking for: genuine ties to their home country, a credible plan to leave if PR doesn't succeed, and an overall picture of someone who intends to comply with Canadian immigration law. The sponsorship in progress is not a black mark. Handled properly, it can actually support the TRV approval. Outland doesn't mean separation. It means your spouse visits, possibly works if they are here on a valid status, and you're building your life together while the permanent residence clock runs. Inland is not the wrong choice for everyone. There are specific situations where it's the only logical option. First, your spouse has fallen out of status. Visitor record expired. Study permit lapsed. Worked without authorization. For those applicants, inland has a specific public policy under Immigration and Refugee Protection Act, Section 25(1), that can waive the status requirement. IRCC can overlook overstays, expired permits, and unauthorized work as long as the relationship is genuine and only violations are status related. No criminality, no fraud, no security concerns. Once application is filed, CBSA provides a 60-day administrative deferral of removal. Your spouse isn't immediately at risk of removal while the file is assessed. Outland offers no such protection for out-of-status applicants in Canada. Second, your spouse cannot safely leave Canada. Their home country is in conflict. They face genuine safety risks, or their home country has a historically high TRV refusal rate, and there's real doubt that they'd be issued a visa to return. For those couples, the physical safety of the inland stream outweighs every other variable. Third, conjugal partners can't apply inland at all. If you're sponsoring a conjugal partner, someone you've been in an exclusive relationship with for over a year but face absolute barriers to cohabiting or marrying, Outland is the only stream available to you. So, inland is not wrong. It's situational, right? The question is whether your situation matches the situation inland was built for. The stream choice is not a form question. It's a strategy question. It depends on your spouse's current status, your risk tolerance, your need to travel, whether there is any complexity in the file. If you want to work through which stream is right for your specific situation before you file anything, book a strategy session through the link below. That's what it's for. And subscribe for more videos like this where I share actionable, practical immigration advice. Thanks for watching.